all for joining me today. I have our wonderful team of attorneys here to discuss H-1B alternatives. I have Attorney Shilpa Malik, Attorney Quindemil, and Attorney Brian Thompto. Thank you all for joining us today as we dive into this really interesting topic. So before we start, can you all give us a quick overview of what the H-1B lottery system is and what it looks like for someone who wasn't selected?
H-1B is one of the most coveted work visas in the United States. Therefore, there is a lot of applicants and employers who are interested in procuring H-1Bs for their employees or prospective employees, whether they're in the United States or overseas. Our focus right now will initially be on people who are in the United States and another status and have not been selected for the H-1B lottery. But prior to that, I would like to explain that the H-1B lottery is a completely random computer-generated lottery that's conducted by USCIS in March of each year. They accept registrations in a 2-week window, which they announce sometime in February. And once those registrations are submitted and that period is closed, USCIS conducts a random computer-generated lottery, which is not based on merit. It's a purely random selection. So I want everybody to know that there's nothing about your specific application that prevents you from being selected or from not being selected. So that said, you have to remember that it's purely luck of the draw. So if you've been selected, congratulations. Make sure you're working with your employer to get the applications filed within the filing window of 90 days, which began on April 1 and ends on June 30th. That said, there may be specific circumstances where an earlier filing may be needed before the last day of June 30th. So please look at your status end date to ensure that your petitions are filed before your status in the United States is ending to maintain continued work authorization if you're on F1 OPT or STEM OPT, or the ability to remain in the US while the H-1B is pending. Now, in terms of the visa options that are available to individuals, it also depends on what their current status in the US is. For people who are on F1 OPT or STEM OPT, possibilities include pursuing a F1 CPT program, an O1, possibly an L1, or even an H3 trainee visa, which we will touch upon briefly as we move forward.
Thanks for that insight, Shilpa, and thank you for that introduction into these different options for the H-1B visa. So you've already touched on this, but I would like to explore a little bit more about those common non-H-1B visa pathways that people typically explore after not being selected in this lottery. So why don't we start by going through each one of those, and maybe let's start with the F1 visa.
CPT option. The F1 CPT is an option that a lot of the F1 OPT and STEM OPT applicants pursue in case they do not qualify for any other visa category based on their personal circumstances. I do want to caution such applicants that be sure that you're picking the right school and the right program, because USCIS closely watches compliance with a CPT program. They want to make sure that it wasn't just a loophole that the individual was trying to use in order to be able to remain and work in the US beyond a certain period of time. So ensure you're able to explain why did you pick up a certain major, why did you decide to study further, and explain the connection between your practical training program and the work that you're currently pursuing or the training that you're currently pursuing with your employer. Choose wisely. That's my advice. When it comes to F1 CPT, the programs can range from 1 year to 2 years. They have a day 1 CPT option. Speak to the school that you're applying to about how to make this happen legally and in full compliance.
Now, there's a lot of talk with student visas right now. So would you be able to clarify any misunderstandings that you're commonly seeing with recent grads trying to navigate this process with their visa?
Well, honestly, it's not so much that anything has changed as far as the regulations are concerned, but of course, the current administration is watching a lot of visa holders very closely. What that really means is that if you've had any interaction with law enforcement, if you've been arrested, you've been pulled over for DUI, you've been charged with DUI, there's a high potential of your visa being revoked or canceled, even if that charge was later dismissed. you will have to likely go back to your consulate and or embassy, the U.S. embassy or U.S. consulate in your home country to procure the F1 visa again in order to re-enter the United States, or speak to your DSO if you're able to seek a reinstatement of your F1 status in these circumstances within the United States. Again, it's not one size fits all, so be sure to consult a qualified immigration attorney about any specifics as they relate to your case.
Thank you, Attorney Malik, for that insight. Now, switching gears here with the O1 visa. This comes up a lot. How realistic is it, and who's a good fit for this type of visa?
Good afternoon. My name is Attorney Quindemil, and I'll be discussing this point. So many people bring up the option of the O as an alternative to the H-1B. Now, it could be a good substitute for an H-1B if you are exceptionally talented in your sector, whether it be in a field of business, education, sports, or sciences. If you have achieved great successes in science, education, business, or sports, you may be eligible for an O1A. If you have had success in arts or in the motion picture or television industry, you may be eligible for an O1B. Now, although this does seem like a very potential option for many people, you must keep in mind that in order to obtain these visas, you need to demonstrate that you have basically risen to the top of your field. You will need to meet, there's 8 delineated possible categories that USCIS sets out, and you need to be able to demonstrate a minimum of 3. We go into more specifics in another one of our videos, but essentially you need to be able to prove that you've risen to the top of your field. And it needs to be demonstrated or documented through reports, through objective evidence, through articles, through hard and fast evidence that supports you being the top in your industry and having national or international recognition. Now, there are benefits to choosing an O1 as an alternative if you qualify for the strict requirements. Now, the O1 is available for application at any time, unlike the H-1B, and it is not lottery-based. So that opens the avenues for applying throughout the whole year. O1 visa holders can also work for multiple employers concurrently, meaning if you have different employers that are interested in working with you, each one can file an independent O application for you, and you are qualified, you're eligible to work for those different employers. You also have the option, there's certain types of O1s that you can have a third-party agent represent you. And through the agency, you're able to have that agent serve as your standard, the way they look at it as an employer. But through that agent, you're able to obtain contracts to work for different companies or work on different projects or work on any short-term roles or long-term roles. So that's another viable option. And also, H-1Bs can only be renewed for a total of 6 years, while O's can be renewed indefinitely at the end of the period for an increment of 1 year, as long as you have an active work contract, you have an itinerary that explains why your work is necessary, and your employer is willing to continue sponsoring you. A big thing to keep in mind is an O1 visa is also an employer-based requirement. So you cannot self-petition, then normally speaking, you would still need to have an employer sponsor you or an agent, as you do with the H-1Bs. And a counterpart to that is also a lot of people want to know about the EB-1s. The EB-1 is basically the green card equivalent for an O1 visa. This requires a higher standard of proof, and it requires demonstrating that you have extraordinary abilities and you have risen to the top 1% of your field. There are a potential of 10 categories that you have to meet. 10 potential categories, and you have to only establish 3. But these need to be heavily documented. And this is normally reserved for if you are a researcher, if you are a published author, if you have been, you're the leader in your industry, they're always inviting you to speak on panels because you are the most recognized individual for your sector. Those are the kinds of people that that USCIS normally looks for in the EB-1As. The benefits to these can be self-petitioned. You do not require an employer to file for an EB-1A. And an EB-1A is the green card equivalent. So it is a pathway for you to later obtain your green card. But keep in mind, the extraordinary ability portion is simply the recognition, or the way I like to look at it, it is USCIS giving you a gold star, recognizing that you have risen to the top of your field, you have risen to the top of your industry. But that alone would not won't automatically get you citizenship. If you are here in the United States and you do not have another means to stay, if you don't have another current visa, then an EB-1A route would not be a good choice for you, because you would then need to file for the green card application, and that normally you would have to base it off of the visa bulletin and your priority dates.
Thank you, Attorney Quindemil, for that insight on the O1 visa and the EB visas as well. I'm curious to know, off this previous lottery, are you noticing a trend with, more individuals opting for the EB visas or the O1 visas? Like, could you share some insight on that?
We are seeing a lot of applicants coming to us to see if they're eligible. Now, whether they are eligible or not, it's a whole different story. But we are assessing these applicants every time they come to us with interest, because many times there are qualifications that an applicant may not know they possess. And until they have a thorough consult with an attorney, it may not come to light. So we are getting many interested parties who are wanting to discuss the O's and the EB ones. But the only way to really determine it is to schedule a consult, because it really involves a thorough discussion and detailed in-depth discussion with the attorney to be able to pace through your resume, as well as have a detailed dialogue with you to see if you have any other accomplishments in your past that maybe weren't on your resume. So this is something that if you think you're interested, if you think you're eligible, if you look at your resume and you think, I think I've risen to the top, then I would urge you, schedule a consult, because you never know what the possibilities of the options can be.
Thank you for that. Now, looking into these larger companies, specifically multinational companies, what about L1 visas? Are these also an alternative for these applicants who entered the lottery and weren't selected?
Thank you, Nirmal. Yes, the L1 visa does work for you if your company has an office abroad, whether there's a qualifying relationship, subsidiary, branch office, that sort of thing. They can transfer you over to their foreign company and put you on the foreign company's payroll for at least 1 year before you're able to apply to transfer back on an L1 visa to the United States and continue working either in a specialized knowledge position or as an executive or managerial role. The L1 visa also has dual intent, so that means you can apply for a green card while you're here on an L1 visa. The only thing to consider with the L1 visa is the L1B does max out at 5 years and the L1A maxes out at 7 years. And unlike with an H-1B petition, with an approved I-140, you're not eligible to continue on the L visa status until your priority date becomes current. Furthermore, the time spent in L visa in the US counts against your 6 years towards H-1B. So if your plan is to transition from L to H-1B eventually, to take advantage of the I-140 approval and going beyond your 6-year max out date, you would need to start that green card process, which can take 3 to 4 years in advance of your L expiring to transition to H-1B and take advantage of the remaining time on the H-1B cap.
Insight. So that's a good point that you touched on, where you mentioned 3 to 4 years in advance for these L1 visas holders that they typically would consider wanting to apply for their green card. Do you see a lot of your current clients doing that process so early on?
Well, it depends on the client, and it also depends on their employer. The employer needs to be willing to do the sponsorship, and under an EB2 or EB3 category, you also have to go through the permanent labor certification process with the Department of Labor. And that's where we're seeing the largest delays in terms of processing times. So that's why it's key to have the 3-year window to start your green card process, lock in your priority date, and then use that I-140 approval if you are able to switch over to H-1B and be selected in the lottery in future years.
Thank you, Attorney Thompto. Now, moving into another category that I see pop up a lot is the E2 visas. This really an option for individuals to explore something like this, or maybe even the EB2 NIW?
It happens to be a very popular visa category, but it's not a scenario which suits everyone. For one, you need to be a passport holder of a country which has the requisite treaty with the United States. And a majority of the countries do not have that treaty for various reasons. Some of them do have it, so make sure your country is on the E2 treaty list. Then you also need to be looking to invest in a business in the United States. So there's a capital amount involved where you need to bring in a significant amount of cash into the US or inventory equivalent to a significant amount of investment in order to qualify for an E2. So if you are looking to set up your own company, run a business in the United States, E2 is a great option to consider, but it comes with some of its own requirements, including an upfront expense, which tends to be fairly significant and has to be proportionate to the nature of the business that the applicant is looking to conduct in the US.
Are there options with a TN visa here for them to apply for?
Because TN is one of the most easily procurable statuses if A, you're qualified, and B, you have an employment offer in a position that is listed under the NAFTA profession list. So please look at that closely if you're a Canadian or a Mexican. The only difference between a TN for Canadians is that you're able to apply at the border or from within the United States. Mexicans are either able to apply from within the United States for a change of status, or they'll have to apply for a TN visa with all the documentation at a US consulate or at the embassy in Mexico or another country where they may likely be residing. So those are also very good options. If you're Australian, you can also look at the E3 visa, which doesn't go through the cap, and it's essentially what's called a sister visa to the H-1B, but it's limited to 2 years at a time. And there's the good thing about the E3 for Australians is there's no 6-year limit. It can be extended in 2-year increments. So I wanted to obviously touch upon these 3 visa categories as well based on your country of nationality.
Yeah, so to close it off with all the alternatives that we discussed, I believe there is still an H3 visa. So how applicable is that for a lot of individuals?
H3, again, is not available to every country applicant, but that said, if your country is eligible for an H3, it's what's called a trainee visa. It's not for the purposes of productive employment in the United States. It's for the purposes of obtaining a training with a US company, which you intend to go ahead and apply in your own country or in a different country once that training has been obtained. Now, the US company has to give some very good reasons of wanting to train an individual in the US for that period of time and then send them back overseas. So that usually works for companies who have offices offshore and are looking to train individuals in the US before moving them to the offshore office to implement their practice, the business practices, or the critical skills that they've learned as part of the H3 training program, which is also a prerequisite for H3 applications, and apply that in that particular office or setup overseas. A company that's owned by an H-1B beneficiary can sponsor their H-1Bs. This was recently introduced in January of this year. So if an applicant owns a company, they can have that same company sponsor them as long as the company can show that the majority of the work that the beneficiary will be performing is directly related to their degree or the major that they took in the United States or overseas as part of their degree. They can, of course, perform some other tasks towards managing the company, but a majority of their work should align or have a nexus with their degree. Also, in terms of the O1, while an O1 cannot be self-petitioned, again, the beneficiary can own a company and that company can sponsor their O1. But one of the major requirements for that is obviously proving that the company has sufficient expert level-like work for that beneficiary to perform in their capacity as an O1 visa holder in that particular field. I want to add that the same applies to an H-1B being sponsored by an employer that's owned or by a company that's owned by the beneficiary, you do have to show that the company has sufficient work for the beneficiary to perform.
Now going into a different segment of this call today, I am curious to know, what is one piece of advice that you wished more international professionals heard earlier in the process before they applied for the H-1B lottery? I know it can be very disheartening not getting selected in the lottery. So what do you advise your clients?
That's a very good question, and I would like my colleagues to also share their viewpoint on that. But from my point of view, honestly, I feel, again, as I explained earlier in this conversation, it's purely the luck of the draw. You don't control the results of the lottery. So while it is disheartening, do not give up. Pursue all possible options that are available to you, including having to relocate to another country or going back to your home country if needed for a certain period of time before other avenues open up. So while this disappointment is real and we understand it, we recommend you to stay focused and recommend that you do not give up. There will be options that will come up if you keep trying, and if you intend to make America home and intend to continue working in the US, just keep looking for those options and utilize your skills or improve your skills to achieve those visas as well.
Final point that I would like to give clients: when you're going into next year's H-1B lottery, have a plan B in mind. Because of how Shilpa explained, it is luck of the draw. So the way that you can lessen the blow for next year is, when you're going into the process, I would suggest reaching out to a with immigration attorney a couple of months before and begin to try to weigh out your options. That way you could possibly have another option for what you can do set up, or another plan of action to take off running if you weren't selected. That way you can already start compiling those documents, having everything ready. And if you're not selected next year for whatever reason, if your luck, it doesn't turn out, you don't have to immediately feel like, what's next? What am I going to do with myself? Speak to an immigration attorney, have a plan B, have that detailed call. Because no matter what, whether you're going to be applying now, whether you're going to be applying later, having a good call with an attorney can help set you up for collecting your documents to get everything organized. So for a later day, you're ready to take off running.
Really great points. I'd just like to add on to that. In terms of having the plan B, that is a good thing to have in mind. And also, right now, when you weren't selected, this is an opportunity for you to strengthen your profile, to strengthen your resume, to potentially be eligible for a different category visa than the H-1B. You also may want to look into who's going to be sponsoring your H-1B visa next time. Is it a company that could potentially transfer you on an L visa? Could they potentially train you on an H-3 visa? Those are things you want to look into while you have the time and waiting for next year's lottery.
So with this, we would like to wish everyone all the best. And as advised by my colleagues, please feel free to reach out to your immigration attorneys or to our firm for any consultations you would like on these subjects.
Thank you to all the attorneys that joined me today on this call to discuss all these alternatives for the H-1B visa. If anyone is interested in exploring those different alternatives, please feel free to check out our website at imi-usa.com, and you can schedule a consultation to speak to any one of our attorneys here on today's call. So thank you everyone for watching, and please feel free to subscribe.